Welcome to the Neighborhood Law Center. I'm your host, Melvin Burruss. And we're lucky to have today attorney Simon Stapleton, whose practice is elder law. And we're going to talk today about estate planning and what you need to know or what you don't need to know or what you need to do with your trust and your assets. Welcome, Counselor. Thanks for coming.
Thank you, Melvin. Good to be here.
Yeah. To get us started, could you tell our audience a little about yourself and how long you've been practicing in this area?
So I've been an attorney now for, 35 years, got some gray hairs to prove that. I grew up in England, in London, and actually practiced law there before I came to the US. Then I was offered a job with a law firm in New York and came over here, worked in Manhattan for 2 or 3 years. Fun experience, but a quick burnout.
I can imagine.
Yeah. So then moved down here to Virginia in the late 80s, and I've been practicing estate planning since then, since around 1990 here in Virginia.
Okay, so let's start off with estate planning. Will you tell our audience, what do you need? Do you need to be rich to do an estate planning and establishing a trust?
No.
Or what is a trust really in estate planning?
Sure. So the answer to your first question is no, you really don't need to be rich. In fact, any adult should have at least some basic documents in place. A will, and a couple of different types of powers of attorney. And regardless of your estate, those are really important documents to have. Because if you don't have those documents in place, then what we find is someone else makes a decision for you if you don't have those documents. And of course, no one wants that.
Okay. When you don't have a will, I guess the state statutes take over to dictate just what you need to. Can you talk about that a little bit?
Sure, yeah. So if you don't have a will at all, then you're absolutely right. There is a list in the Code of Virginia. So basically, the Commonwealth gets to decide where your assets, where your money goes.
Okay, so in this trust, what goes into this trust that we're talking about, this estate planning trust?
Okay, so many people decide, instead of having a will, they decide to have a trust. So a will is good because, as we talked about, it says when, how, who you want your assets to go to. But the will does involve a probate process, which is a bureaucratic, can be expensive, time delays, court process through the will. So some people say, no, I don't want to go through all that, let's do a trust instead. Now the trust completely avoids the whole probate process. The trust is more like a private contract between you and your family. And you may say, I want my wife to get this property, I want my kids, grandkids to receive property. And that's all laid out in a trust. So back to your question, what can go in a trust? Really pretty much anything. The house, of course, it's good to have the house in the trust. And then financial assets, they go in the trust as well. So stocks, bonds, mutual funds, etc.
So what excluded financially investments do not go? You mentioned before the IRA, and why is that?
Yeah. So anything that has a specific beneficiary designation, so as you said, an IRA, that would not go in the trust for tax reasons because it's a taxable event. IRA, of course, stands for individual retirement account. So for that reason, for tax reasons, we wouldn't put the IRA in the trust. Also, typically, life insurance would not go in the trust because those are assets that they have their own beneficiary designations on them.
You know, we're talking about kind of like your final the final thing you want to do before you go to rest.
Right.
And I'm just wondering, what are the types of clients that a trust can help? When do you have to start thinking about establishing a trust, establishing estate planning?
Right, right. That's a good question. Really, I always tell folks it's never too early. There are different types of trusts. So as we say, for example, let's say we get married, we have children, we buy a home, those are times where we should be looking at estate planning. How do we take care of our children? There are different types of trusts. There's what's called a revocable living trust, which most people are familiar with. And a lot of time, folks, say in their 40s or 50s, will set up that revocable trust to deal with the house and other assets. Also, life insurance is important with young children, something to think about as well. God forbid if something happens to the breadwinner, then we have life insurance then to take care of the young children.
Is the life insurance part of the trust, or is that a separate?
It's separate, but when I'm talking to clients, especially folks with young children, I like to bring that up as a topic of conversation because it is so important.
What are conditions, medical conditions, that you have to keep in mind when you're talking to people about establishing a trust, or along, I guess, the spectrum of when do I do this?
Right, right. Well, when we're talking folks a little bit older, perhaps in their 60s and older, things that I look out, that I watch out for are dementia, Alzheimer's, other form of dementia, Parkinson's disease, MS, all those kinds of degenerative diseases where it's even more important to plan in those circumstances and to plan earlier. A lot of folks are familiar with Parkinson's, with the tremor that happens with Parkinson's. So just physically, we want to have those documents, especially powers of attorney, have those powers of attorney in place while someone is still physically able to sign, as well as mentally. Of course, the law says that the person signing has to understand what they're signing. So that's particularly important with dementia, to catch that early on, perhaps get a letter from a doctor saying, yes, he or she is capable of understanding this legal document.
Okay, so what is this package we're talking about? Putting what into this trust? What are the documents that go in there?
Right. So the trust itself, of course, which is a legal document, then that becomes the will, effectively. So the trust is the document that says who I want my assets to go to. And then the deed to the home, we would put the deed to the house in the trust, any other real estate that's owned. A will, we still have a will in place even if we have a trust, but the will is what's called a pour-over will. So in other words, if there are assets outside of the trust, like a vehicle or a bank account, that pour-over will catches those assets, pours them over into the trust, meaning they don't have to go through probate. So the goal with the trust is to completely avoid the probate. And then a couple of other important documents are financial and medical powers of attorney. And we do those as two separate documents. So the financial power of attorney would be, who do I want to write checks, pay bills for me if I'm not able to do that myself? Oftentimes, if we're married, that would be a spouse. But oftentimes, spouses travel together. So good idea to have a backup. If I name my spouse, she's unable for whatever reason, then I would say my son, he can sign, write checks, pay bills. So that's the financial power of attorney. And then equally important, of course, is the medical power of attorney. We see that referred to as different names: advanced medical directive, medical power of attorney, living will. But those are all different names for describing who do I want to make medical decisions for me, again, a spouse or another loved one, and what do I want those decisions to be. So for example, with a living will, that's a document that says if I'm on a life support machine, let's say I'm in a coma, and the doctors say there's no chance of recovery, there's no coming back from this coma, I'm likely to be permanently in a vegetative state, then we have a document called a living will, and a lot of people in that situation say, I don't want to be kept alive indefinitely by machines. So that's part of some of the tough conversations we have with folks in making these decisions.
Especially if your brain dead.
Exactly.
Yeah, no coming back.
A lot of people say if I can't really have a meaningful life, you know, if I'm just have a feeding tube, I'm kept alive, you know, I have a breathing machine, a lot of people say, no, I don't want to live like that.
Okay, what is some of the dangers we talked about? You call it a protection plan. Mm-hmm. What are some of the dangers of not setting up this protection plans or a trust?
Right. Mm-hmm. So specifically the asset protection trust, which is the one, as you mentioned, that can protect the assets. So the dangers of not having that are, if we go back to the example of the person with Alzheimer's or another form of dementia, the cost of a nursing home to take care of someone in Virginia now is $8,000 a month and up. You know, it can be even more than that. So the dangers of not having a plan in place are that's going to be money you have to pay out of pocket for a caregiver to come in, for assisted living, or all the way on up to a nursing home, as I say, $8,000 or $9,000 a month. So the dangers of not planning is those assets are going to be gone. Let's say the husband has Alzheimer's. Well, even if the couple have significant savings at $8,000 or $9,000 a month, chances are, you know, their savings are going to be gone quickly. So then what does the wife live on? How does she survive financially? So that's why it's so important to plan in these situations.
Okay, let's have a break. We have some new folks coming in to watch the show. This is the Neighborhood Law Center. I'm your host, Melvin Burruss. And we have today elder law attorney Simon Stapleton. And we're talking about a trust and financial planning and what you need to know to protect your assets once you're gone or while you're still here. Now, one thing we didn't talk about, who has control of this trust while the person, for instance, myself, is still alive?
So you do. The person that creates the trust is called the trustee or manager of the trust. So one of the differences between a will and a trust is, of course, a will only comes into effect when you pass away. A trust, on the other hand, it's referred to as a living trust. So you, as trustee, as manager of the trust, you're in charge, you're in control while you're alive. Meaning if there are assets in the trust, let's say investments, you can choose where that money is invested, you can take money in and out to live on it during your lifetime.
Okay. One question I have is, some of my viewers have asked me, you mentioned assets, let's say stocks and bonds, are in the trust. Now, if they have a beneficiary, do we need to put them in the trust or you keep them out of the trust?
We can keep those assets outside of the trust if they have a beneficiary. Now, the only caveat, the only warning I would say to that, if we are, for example, planning for someone with dementia, someone who's older, who may be concerned about a nursing home stay later on, then the more assets we have in the trust, the better, because those are protected. So even assets that have an existing beneficiary designation on, it may make sense to disregard that beneficiary designation and put them in the trust again for protection purposes.
Okay, well, when you do that, that's when you then start allocating who gets what within the trust.
Correct, and the trust does that.
Okay, what are some of the myths or misconceptions that stop folks from getting this protections, this legal bonus, this legal protection that you're referring to?
So, one big reason why folks don't do this is procrastination, honestly. Especially us men, we think we're invincible, we're all going to live forever.
Going to live forever. Huh?
Yeah, and oftentimes if it's a married couple, it's often the wife who's the first to come along to contact us, and then the husband kind of follows suit, but usually hopefully understands the importance of it. So procrastination is one reason. Another reason, another myth that's out there as far as protection is concerned, is that it's not possible to protect the assets, is another myth. Mm-hmm. And that's not true, especially if we plan early on, we can protect those assets. One thing to be aware of, though, Melvin, is if we're planning for a Medicaid, there is a 5-year look-back period. Meaning if the assets, if a trust is created and financial assets, homes are put in the trust, then Medicaid can look back at that transfer to the trust for a period of 5 years. So it's important to do that. Again, plan when you can, as early as possible. It's important to do that, to set up the trust, get those assets in the trust ahead of time because of that Medicaid 5-year look-back period.
Okay, so whether it's in a trust or outside of a trust, you can't get around that 5-year period, I see.
That's a whole nother area, Medicaid crisis planning, but there are certain types of annuities. There are different strategies that we can put into place if the person is in crisis, meaning they're about to go in or already in a nursing home. There are still things that we can do, still worth reaching out. But the best thing, of course, it's always better if we can to plan ahead.
Okay. One thing we've found, especially around Central Virginia, a lot of folks lose their real estate because of tax purposes. Mm-hmm. They don't pay it, or they don't know about the taxes.
Right.
And a family member may be living out of state and things like that. Mm-hmm. How does the trust help someone like that? Because a lot of folks just lose real estate property. They don't, because of taxes or other reasons.
Right. Yeah, that is sad, and I've seen that situation also. Oftentimes it happens if a person passes away, and as you say, then relatives are out of state and don't know about it. Or someone is older, dementia, they forget to pay those real estate tax bills. So one advantage of having the trust is you have another trustee or another manager, if you will, named in the trust. So that relative who's perhaps out of state, hopefully a younger person, they can be involved in the trust, in the management as well, make sure that the real estate taxes are paid, other bills are taken care of, so hopefully you don't have that situation where the real estate might be lost to an unpaid tax bill.
The question I was asked, can someone, for instance, that's an heir to a real estate property, can they initiate establishing their own trust and putting their share of the assets or the real estate into that trust?
They can, yeah. An heir can certainly do that. And oftentimes we do that with family properties. You know, there might be 5 or 6 family members who own a certain piece of property, but one of the owners who comes to me to plan, let's say there's 6 owners, but we can put their 1/6 share into their trust so that their share passes on to who they want it to go to.
Okay, well, that's good to know. Now, I guess what I want to say is, what should a person look for when they're talking to a elder law attorney or trying to establish a trust in estate planning?
Yeah.
What are some of the things they should be asking?
So they really should, first of all, as far as the attorney themselves is concerned, it's very important to ask, do you have experience? Have you done this before? I set up one of these trusts once or twice a week. So, you really don't want an attorney who maybe does one every 10 years. You really should look for someone who specializes in this area. There's a good resource called NAILA, which is NEALA. In Virginia and here nationally, that's a National Academy of Elder Law Attorneys. So if someone has taken the trouble to learn and take the courses to be part of that organization, chances are they know what they're doing.
Okay. Look like we're running out of time. Thank you. We've done quite a bit. Let me ask you this, though. What do you want to leave with our audience? What do you, 3 or 4 different things that you think the audience should take with them after this presentation?
Yeah, thank you. That really is an important question. So it's never, the first thing that I would like folks to realize that it's never too early to plan is number one. Number two, this doesn't have to be terribly expensive, it's very important to have at least those basic documents in place. So a will is important. Yes, we may look at a trust later on, but at least have a will in place. So you get to decide where your assets go to. And then a power of attorney, financial, medical, so you have someone you trust and love making your decisions for you. And as we get older, consulting with an attorney to look at a trust, does a trust make sense for me? What type of trust? Should it be a revocable trust, or should it be an asset protection trust if we're older or concerned about medical bills?
One thing is, do you follow up with your clients, update these trusts every 5 years, 2 years?
I do, yeah. We have an annual maintenance plan. We don't always meet every year, but I meet with folks. Perhaps they come to one of our workshops. We have them at the library, and we have them online as well. Oftentimes they come to me, it's been 15, 20, 25 years since that will was looked at. So we have an annual maintenance plan to set up the right type of trust in the first place and to keep it updated.
As people, lives change and
exactly.
Children grow up or grandchildren come, this living document that you refer to keeps changing along with it.
Exactly.
Okay.
Yeah.
So what inspired you to do elder law?
So I have had some dear friends. In fact, they became the adopted grandchildren of our children here in Charlottesville, because on both sides, the grandparents had either passed away or were not local. So they were here in Charlottesville, and their names were Norman and Florence. And Norman called me one day very, very upset and said that Florence had been diagnosed with Alzheimer's and could I help? So that really started me on that elder law journey, planning for them. And I'm honored to say that since then, that was 20 years ago now, since then there have been many Norman and Florences I've been able to help along the way.
Okay. Well, thank you for coming. I'm going to want to leave your address or where people can contact with you.
Sure. Yeah, love to do that. So elderlaw-va.com. That's our website. There's a lot of videos, really great information on the videos on the website. Or, of course, they can always call my office, Stapleton Elder Law, and that number is 434-293-7788.
Okay, we're going to wrap it up. Thank you for watching. This has been the Neighborhood Law Center. Remember, you can, if you missed part of the show, you can get us on neighborhoodlawcenter.com. We're also on YouTube, so just type in neighborhoodlawcenter.com, and we'll pop right up there. So thank you, Counselor, for being here and being a part of this, and we appreciate your time.
Yes, sir. Thank you.
Peace and God bless.